Back here at home, the President and the First Lady attended the investiture of the newly appointed Supreme Court Justice Ketanji Brown Jackson on Friday. Now, the formal ceremony comes as the court begins its new term this week. Meanwhile, a few of the justices have been sparring with each other in an unusually public way. And for more of these details, we want to welcome in Amy Howe. She is the co-founder of SCOTUS blog. And Amy, it's good to have you along as we reach this first Monday in October. Let's talk about this dispute here. We are in an area where we're seeing things out of this court that we've never seen before. Are we making too much out of this, or we actually entered a new time in the court's history?
It's a new time, at least for now. I've been covering the court. We founded SCOTUS blog almost 20 years ago, and I can't remember anything like this. The justices like to say that they speak to the public through their opinions, and sometimes some of them do give speeches that make news, but to have them publicly taking pot shots at each other like this is really unusual. What
purpose does this serve on both sides too? Because what ultimately gets decided in the court is what the justices vote on. Why should public opinion or trying to spin out what the court is or is not relevant in this arena?
It's not really clear what they think their purposes are. I think that two things are important about it, though. The first is when it's happening. The justices are getting ready to go back for their new term, and usually they've had the summer to kind of cool off and reset. So the fact that they are still firing these salvos right up until the start of the new term suggests there's a lot of frustration.
How much of this has to do with the fact that this is a relatively young court as it is currently assembled right now? We have justices on the court that have just been confirmed and placed on the court in the last couple of years. We're going to have a brand new one this week. Is this a situation where people are getting to know each other and feel each other out? Or is there a means to an end here in these public statements about the court?
I don't know about the means to an end, but the two of the people who have been sparring are Justice Samuel Alito, who's been on the court since 2006, and Justice Elena Kagan, who's been on the court since 2011. And what I really think is interesting is that Justice Kagan is one of the people who's speaking out. She's someone who's usually very careful with her words, doesn't make news with her speeches. And the fact that she's speaking out now suggests to me that she is deeply frustrated because she's looking at the possibility of a 6-3 conservative majority for the foreseeable future with a lot of new contentious cases coming up.
So the Chief Justice of the United States, John Roberts, is in the middle of all of this. How much sway does he have over these justices to maybe call them in the locker room and say, hey, cool it with this?
He can try, but I like to say that the Chief Justice is really the first among equals. I think there's a little bit of an element of herding cats. These are some very strong and opinionated people who are going to do what they want to do.
Obviously, issues are not important that don't get to the Supreme Court. So there was a couple of cases, at the beginning here that we want to ask you about. Harvard University as a case involving admissions. What is the court going to be looking at with that, and how could that change things depending on how they rule?
So in 2003, the Supreme Court had a case involving the consideration of race in the undergraduate admissions process at the University of Michigan. And in that case, the Supreme Court said that universities can consider race as part of a sort of holistic inquiry in their admissions process to further a compelling interest in having a diverse student body. And so in the Harvard case and a similar case out of the University of North Carolina, my alma mater, the justices have been asked to overrule that decision. It is a very different court. Justice Clarence Thomas is the only one who's left from 2003. It's a more conservative court. And even the decision in 2003 said, we hope that schools aren't going to need to consider race in 25 years.
But this is an issue that the Supreme Court has been dealing with for decades. Go back to Alan Bakke,
right.
30, 40 years ago. Is there anything that exists actually as settled law, as precedent, or are these things constantly up for reevaluation?
There is settled law. In 2003, they said schools can consider diversity, and they have been asked to overrule that. There are other sort of off-ramps that the court could possibly use to perhaps rule in favor of the challengers in this case without actually overruling its decision in 2003, but that's what they've been asked to do. And this is a very different court. You know, the abortion case, you had Chief Justice John Roberts sort of in the middle, but he's someone who, in a case a couple of years ago involving the consideration of race and allocating public school slots, said the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. So he could very well be in the majority.
Is it safe to say Roberts is a swing vote in this?
You know, I think he may be concerned about overruling precedent, as he often is, and about what it will mean for the court, the public's perspective on the court. But you know, I don't know that he's necessarily a swing vote.
Amy Howe, thank you for joining us this morning, co-founder of SCOTUS blog. Good to have you here.
Thanks for having me.